Hi, my name is Robert Gibson, and you're listening to Environmental Soup through the facilities of Trent Radio or on my YouTube channel. I'm trying to record this on YouTube as well as recording on Trent Radio through the facilities of Trent Radio, I should say, and I'll see how that works. I might have to make this into a shorter video if I have pauses, too many pauses, or a few separate videos. Anyways, I'll get into the episode. Today I'll focus on municipal zoning orders, especially in ones that impact provincially significant wetlands, and why this matters in terms of justice and environment and people. First, Indigenous women in this area, Northern Peterborough, have specific roles in caring for water, and wetlands have significance for First Nations as well as providing food security. For many local First Nations, water is a living being, and as a settler, it is important to keep this in mind when talking about wetlands and municipal zoning orders. And there's also habitat for wildlife. It's very important for a number of reasons. I should define what a municipal zoning order is, an MZO, before continuing further. Municipal zoning order is a planning tool that a government minister may make as empowered by Section 47 of the Planning Act. They can do what councils do, including, but not limited to, prohibit the use of lands, prohibiting the erecting, locating, or buildings or structures, prohibiting the erection of any class or buildings or structures on land that is subject to flooding, or land with steep slopes or that is rocky, low-lying, marshy, unstable, hazardous, subject to erosion or natural or artificial perils, prohibiting any use of land and erecting, locating, or using any class or classes of buildings or structure on land that is contaminated, that contains a sensitive groundwater feature or sensitive surface water feature, or that is within an area identified as vulnerable area in the Drinking Water Source Protection Plan that has taken effect under the Clean Water Act. Prohibiting any use of land and erecting, locating, or using any class or classes of building or structures within any defined area or areas that is significant wildlife habitat, wetland, woodland, ravine, valley, or area of natural and scientific interest that is a significant corridor or shoreline of a lake, river, stream, or that is a significant natural corridor, feature, or area. There are more powers under Section 34 of the Planning Act, and if I read every single one of them, that would be, this entire video would just be reading from the Act, and I'm sure that you wouldn't like that. But those subsections 11 to 34 under Section 34 of the Planning Act don't apply to the minister that makes the municipal zoning orders. And this is problematic because there's no opportunity to go to a tribunal. There's no information required for public understanding or open houses, no meetings with the public, and it's not accountable or transparent, which are two items that have been brought up in the throne speech, which the government should follow as they made the throne speech. It's not really for the people either, because the people have no say in a Minnesota zoning order. Environmental Defense said as of August 28, 2020, more than 133 MZOs have been issued. But I'm not sure if that's a typo or like 133, because that's significantly more than what has been issued in the past over 10 years. And they, quote, allow Municipal Affairs and Housing Minister Steve Koch to make a ruling on how a piece of land is to be used in the province with no chance of appeal by municipalities, citizens, or environmental groups, end quote. Quote, the order included approval of the destruction of 3 small protected wetlands to make way for a large warehouse and distribution center in Vaughan, and another to allow a retirement community to be built on farmland in Markham and Witch Church Droughville. And another case, the Toronto Region Conservation Authority said that due to Ontario Regulation 159/21, they gave permission under duress to destroy a provincially significant wetland. Quote, they provided permission to interfere with and develop within a provincially significant wetland and place fill and site grade the property known municipally as 1802 Bailey Street in the city of Pickering for the purpose of future development approval by the province through a municipal zoning order. This is also against the provincial policy statement, which the current government created. They're going against their own planning documents that all planning decisions have to follow. It doesn't make any sense to develop a wetland. And they went into why wetlands are important in the hearing that lasted like several hours. They talked about how it creates habitat, erosion control, flood reduction, climate change mitigation, etc. And they went in depth. There was over like 1,000 pages of 1,000 pages in a report by the Toronto Region Conservation Authority staff. A lot of it did include submissions from the public as well. And these wetlands, like wetlands are under constant threat. And there's only 75% of wetlands in southern Ontario have been lost. And even more in some places. In the city of Pickering, there was only 1% of wetlands left. And for a healthy ecosystem, there should be at least 10% wetlands and 30% forest. And this isn't the case in the city of Peterborough. And I also know that wetlands provide habitat. Provincially significant wetlands, I should say, they have a lot. There's a lot of work that goes into making a provincially significant wetland. There's a lot of community campaigning that goes into it. And because there's also a 260-year backlog of evaluations, according to the former Environmental Commissioner, Diane Sachs. So, if you're destroying wetlands that have provincially significant status, why do we go through this entire process of protecting wetlands? It's going to set a lot of the protections back decades. There's no confidence. The people will lack confidence. There's no accountability to protections. And a lot of the times, there's an excuse that, oh, there's degradation. The wetlands are no longer they've been degraded. And then people justify that as development. I don't believe that for a second. We need to have funding to maintain wetlands that are protected because we have so few of them. You can't just build a wetland and expect it to have the same functions. There's an entire science around that process. And it takes years to go back to what it was before, and it's not going to be the same. You're going to lose some of that value, or the cultural aspect. And there's a lot of ethical considerations around that as well. And a quote from the Toronto Region Conservation Authority says, unequivocally, TOCA's Board of Directors and staff using a science-based approach to decision-making and TOCA's Living Cities policies would have declined permission of this permit had the province not intervened. There are 20 conditions, and the developer appeared to only agree to 8 of them. Some of them are prior to execution of the agreement, the permit holder shall obtain written confirmation from the Minister of Natural Resources and Forestry, confirming that the Ministry has no objection to the removal of 18 hectares of provincially significant wetland, and that the Ministry supports the ecosystem compensation plan as appropriate and adequate mitigation of the ecological impacts of the granting of permission, end quote. And prior to the execution of the agreement, the permit holder shall provide a cash payment to the TOCA to secure the annual cost of property taxes and maintenance of the lands to be conveyed to the TOCA, and the lands legally defined as PT, LT, 7, Con, 8, Pickering, PT, 1, PL, 40, or 18008, S/E, PT, 1, PL, 40, or 19990, City of Pickering, for land-based ecosystem compensation, as well as the annual cost of property tax and maintenance for the additional lands required to be conveyed to the TLCA for wetland restoration at a rate of not less than $465 per hectare, plus property taxes in perpetuity. And those are two that they disagreed with. I'm not going to read the entire list. But yeah, some of them are very harsh on the developer. And they should be. Because this is the highest protected land that we have. And it's being developed. Or proposed to be developed. Yes, I said that there's 1,000 pages of the report in the summary, and there was lots of reasons for rejecting the proposal to develop wetlands, which the Toronto Region Conservation Authority, their hands were forced upon them. And those changes that make even the conditions, those changes to make even the conditions hard to impose as well, so that they might even be weakened further. And this isn't just in Pickering too. I'll get into some of the other areas. And there's a map that you can make to find areas with wetlands that the Ministry of Natural Resources have, and I'll expand on this at a later time. But if you're looking at a proposal, you can look at the proposal and see that there's a wetland nearby or within the site. A lot of the times they won't directly use wetland in the Minister's zoning order. They might use other language like natural heritage or something else. But it's important to understand where the wetlands are, and the Ministry of Natural Resources has that. And yes, I did say this, destroying wetlands is bad practice because not many are left. They provide habitat, increased biodiversity, reduced flood, mental health benefits, cultural and education soil retention, among other benefits. And biodiversity loss is a huge thing, especially in the pandemic. There's been scientific reports that have linked biodiversity loss to future pandemics. It's not just in the global south where a lot of the viruses have originated or appear to have originated. There will be viruses in the global north that will emerge because of a constant removal of natural spaces. And when I say natural, a lot of the time natural is a colonial term as well, because there's a lot of areas that have had involvement from First Nations that have caused a lot of environments to look the way they do. So that's something else that needs to be considered. Yes, and Amazon actually moved out of a development, one of the developments, due to the backlash. The battle isn't over, and this development has still been approved, but the developer, as well as the mayor of Pickering, seem to be backtracking on the development of the wetland. Somewhat cynical about this, but public pressure does appear to work. But there's still more work needs to be done because it's happening everywhere in the province of Ontario. Any municipality. There was a highway that was going to go through several wetlands as well. And there was a website called Yours to Protect, which also has a map. And on that map, you can see, oh, that's a different one. There was another one that had a map. But this one is yours-to-protect.ca/ministers-zoning-order-map/. And here's a few examples from the site. Aurora. This municipal zoning order disregards Aurora's municipal plan and will allow single-family homes to be built on a surviving parcel at the edge of the Oak Ridges Marine. While the province justified the issuing of MZO on the basis that it would allow for the construction of a long-term care home, the property was in fact already zoned institutional. And it goes on to say that it would allow a residential spa. Caledon. This MZO permits a large codependent spa development on farmland in Peel region. And there was vocal opposition by the Peel region. And there was a connection to political donors to the Conservative Party. The East Humble River Wetland Complex, and this is all from the website. This MZO allows the destruction of prime farmland and 3 provincially significant wetlands in an area that currently has rural character, threatening the habitat of an endangered species to make way for a Walmart distribution center. And then there's a former cabinet minister with the governing party who owns the company. And Horizon Landing Development, St. Mary's River Coastal Wetland. An MZO has been requested to build a total of 200 residents on 130 hectares within a coastal wetland on the St. Mary's River and surrounding nearby Mary Ann Lake west of Sault Ste. Marie. It was previously rejected by the Ontario Municipal Board, and most recently the City of Sault Ste. Marie rejected the push for support of the MZO for the project. So that goes against what they've been saying, that, oh, they just do it for municipalities that support the minister's zoning orders. But no, that's not the case. And some of it is that, like, the mayor may have supported it, but they didn't go through council, or other areas. There was also a map in the article, exclusive Doug Ford donors benefit as fast-track developments, and developments override environmental concerns. And in the National Observer, 14 of 38 MZOs the newspaper looked at had environmental concerns. And quote, critics say the Observer analysis shows that the Ford government use of MZOs is lining the pockets of progressive conservative donors, or causing long-term damage to the environment, end quote. And quote, the developer, and then I have in Vaughn, argued the wetlands were already on a decline and should be reclassified. There needs to be a duty to restore wetlands that are degraded. And did they have an ecologist look at the wetlands? I do not know, but they should also have an ecologist look at the wetlands. And if it's protected, it should be permanently protected. Because if there's no reason to protect it, then developers could just send invasive species in a wetland, or cause something upstream, and yeah, they could just wait it out a few years. By there's vandalism that could occur. Like that's a ridiculous argument that if it's damaged, then we shouldn't protect it. And wetlands are not static either. There's an idea that wetlands are always pristine areas, but the wetland in the natural world, wetlands get destroyed by flooding, excessive flooding, fires, etc. But they have to be able to, but if they're paved over, they don't have a chance to regenerate back into a wetland. And they're permanently lost. And that's a problem because of pavement. The rain permeability increases the velocity of rainfall events and increases flooding. And if you're building in a wetland, you're going to be flooded. There's a reason why it's called a wetland. You don't build houses next to a wetland. Why? What reason are they thinking? Like, insurance rates are just going to go up. They're going to skyrocket. And that's not affordable housing if you're next to a wetland. And it's almost at the half-hour mark. So I'm just going to say that Welcome everybody. I'm just going to wait until it's actually the half-hour mark. Hello, everybody. Thank you for tuning in. If you missed the first half hour, I will be posting this on to YouTube. But you're listening to Environmental Soup through the facilities of Trent Radio, all through my YouTube channel. I'm trying to work it out so I can record on YouTube as well as through Trent Radio at the same time and see how that works. I know I can do it through Zoom. But yes, the first half hour I talked about municipal zoning orders and some of the zoning orders in Ontario, a bit of why wetlands are important, and I still plan on talking about municipal zoning orders because it's a huge topic. Yes, and yeah, and then those an article, "We Will Never Stop. Ford government approves 6 new zoning orders as backlash grows in the National Observer that 3 MZOs out of 6 ones overrode environmental concerns from plateau developments." And quote, "They donated thousands to the provincial conservatives in 2018. That and the amount of MZOs is more than twice as many as the previous government used during more than a decade in power. So that gets to the main issue. Like they're overusing something that was only meant to be used in exceptional circumstances. They used Elliott. The article used Elliott Lake, for example. Like a mall collapsed, and it was the only mall in town, so they have to build a new one. So yeah, that's understandable to use an MZO for that. But to use it to destroy wetlands that are protected under the law, that's disgraceful in my opinion. The Ontario Federation of Agriculture says, quote, "This frequent use undermines Ontario's long-established system of land use planning under the Planning Act, provincial policy statement, and municipal official plans and zoning bylaws. It deprives citizens impacted by these MZOs the ability to be consulted on proposed amendments to the municipal official plans and zoning bylaws." Schedule 3 of Bill 257, Supporting Broadband Infrastructure Expansion Act 2021 says, "The Planning Act is amended to provide that municipal zoning orders made under the Section 47 are not required and are deemed to never have been required to be consistent with the policy statements issued under Section 3.1. However, any part of such an order that applies to land in the Greenbelt area is and always has been required to be consistent with the policy statement issued under subsection 3.1. So what they're saying is they never had to listen to their own policies. They never had to listen to people. They could always build on top of a wetland that could flood. there's reasons why you don't build a nursing care center in the middle of a floodplain, because in an emergency situation, the seniors, like, why? Come on, the government of Ontario. You're putting lives at risk by building, like, one of the proposals was to build a nursing home, like, on a floodplain. Like, sometimes they don't make any sense. Those reasons why they have what they have, like safety reasons. And then, yeah, if I have time, I'll find that section of the Planning Act, but definitely safety is a huge concern. And then if you're filling in, if you can build anywhere, then you're increasing sedimentation, so you're affecting downstream habitat. So not even just where the municipal zoning order applies. You're affecting everywhere around it. There's no consideration for cumulative effects either. It's I don't know. And then I believe that every municipal zoning order which seeks to develop provincially significant wetlands is in direct violation of Ontario's Planning Act, because Section 1 of the Act, I think it's Section 2, might be Section 2, states the minister, the council of a municipality, local board, or a planning board, or the tribunal in carrying out their responsibilities under this Act shall have regard to, among other matters of provincial interest such as the protection of ecological systems, including natural areas, features and functions, There are other items that could apply to provincial significant wetlands, such as cultural significance, safe and healthy communities. And while they do not have to also consider employment, while they do have to also consider employment, there are plenty of land available on brown sites for employment. And the key word is shall in this. So if they're building on something that's already significant, is the Minister of Housing actually considering wetlands or ecological systems? I don't believe so. I don't see how the minister could consider ecosystems if they're just going to develop anyways, like on something that's protected. Doesn't make any sense to me. Yes, and I went to a hearing, a committee hearing on Bill 245, which is somewhat related to this episode. And it's about access to justice, and I presented there, and I will share what I have said. And my you had to go to a different Zoom account to register. It's very, very formal, and you like the set time is the set time. You literally only have 7 minutes to speak if that's your time. And you also have to prepare to answer questions from the government, the opposition, and independent members. And it's beneficial to submit comments ahead of time in writing, which I didn't do. I just spoke. And they like to know your background. And that's the question that I was asked. So yes. Oh, and I made several like edits. Or I practice a lot to get this down as close to 7 minutes as possible, as well. So that took some time to add and subtract and to the speech. But I'll show what I have. I'm here because I have concerns about changes impacting environmental law regarding Bill 245, Accelerating Access to Justice Act 2021. Dr. Robert Ballard in the U.S., known as the father of environmental justice, found that hazardous sites like landfills and incinerators, which often have environmental contaminants, were more often located in predominantly black neighborhoods. Equal Justice has an article pointing out that environmental racism in the Canadian context is an example. Has an article pointing out environmental racism in the Canadian context. An example is from the Chemical Valley in Sonia, which is impacting a First Nation there, or mercury pollution in the English Wabagon River. In addition to this, different First Nations have cultural traditions and relationships which are negatively impacted by environmental harms. I bring up the fact that BIPOC individuals are impacted the most from environmental pollution because Schedule 6 combines multiple environmental tribunals, which includes specific expertise that could be lost, with one body. This is also an argument that the Canadian Law Association makes in more detail. Schedule 10 is problematic because it may take away the public's right to appeal decisions to ministers. Often this government has changed legislation after lawsuits or used minister zoning orders to cancel the public's rights to so people can't have justice. This is not accountable or transparent. Under Section 38(1) of the Environmental Bill of Rights, it says, any person resident in Ontario may seek leave to appeal from a decision, whether or not to implement a proposal for Class 1 or 2 instruments, of which notice is required to be given under Section 22, if the following two conditions are met. The person seeking leave to appeal has an interest in the decision. Another person has a right under another act to appeal from a decision whether or not to implement the proposal. There should be reforms in this area which are not included in this bill to reduce barriers going to court. However, Section 17 of Schedule 6 is especially problematic. Quote, except as may be provided for under this or any other act, a person who is not a party to proceeding may make submissions to a tribunal with respect to the proceedings in writing only. This does not allow for cross-examination and limits expertise. Section 19C(1) is problematic and defeats the whole point of going to court because it is unknown how a case will turn out before a judgment. The Canadian Law Association says, quote, Schedule 6 and 10 of Bill 245 were introduced in the Ontario Legislature without any pre-consultation with CELA or client communities or other environmental stakeholders. This is concerning. The Government of Ontario has a history of not consulting with the public on environmental issues. This is especially true of MZOs that would skip this process. And the natural environment should have standing. This bill doesn't include them as having rights. They should because they are often taken for granted in law. As there are all significant changes to environmental law as a result of changes to environmental tribunals and decision-making, this should be posted on the Environmental Registry. Section 15.1 of the Environmental Bill of Rights says, if a minister considers a proposal under consideration in his or her ministry for a policy or act, could, if implemented, have a significant effect on the environment, and the minister considers that the public should have the opportunity to comment on the proposal before implementation, the minister shall do everything in his or her power to give notice of the proposal and the public at least 30 days before the proposal is implemented. I do not believe that this has been done. Schedule 5 of Schedule 6 says only one member counts towards quorum. This number is too low. In no ballroom is one person used for quorum. The speech from the throne was called a government for the people. If people aren't consulted on the environmental registry, then how is any of this for the people or accountable? And I use the speech from the throne on purpose because it's a document that, a speech and a document that the government must follow or agrees to follow for the term that they're sitting, or at least the year. So I have 10 minutes about, so I will look that up, what I said I would. I will look up the Ontario Environmental Policy Statement. And then, not environmental, Ontario Policy Statement. And this policy statement was updated in 2020, and I'm going to download it. Just to find the section, no, okay, Tom Kill. Okay, I'll type wetlands. Yes, section 2.1.4 says development and site alteration shall not be permitted in significant wetlands in ecoregions 5E, 6E, and 7E, and significant coastal wetlands. They have been, a lot of MZOs have impacted significant wetlands, and one that I talked about is proposed to impact a coastal wetland, significant wetland. Maybe natural hazard. Natural hazards. So section 3.1 talks about natural hazards. And 3.1.5 says development shall not be permitted to locate in hazardous land and hazardous sites where the use is an institutional use, including hospitals, long-term care homes, retirement homes, preschools, school nurseries, daycares, and schools. So that's what I was talking about, that section, when I did my rant about the government not thinking about safety. And then how does it define natural hazard? Does it so definition of natural hazards. Yeah, I don't think that there is a, I think it's just like areas that, areas where there's an unacceptable risk to human health or safety or of property damage and does not create new or aggravate existing hazards. That's what I thought. And they want to reduce the potential for public cost or risk to Ontario's residents from natural or human-made hazards. So a lot of these proposals, they put people in harm's way. So I don't have a lot of time left. I will see if there's anything new on the environmental registry. In terms of policies, acts, and regulations. And I made a video about going through the environmental registry. And it's loading. So there's 16. So there seems to be a couple of new ones. Two new ones anyways. There's the updated flare monitoring guidance under the local air quality regulation. And that has a number of 019-2761. You can comment on that until April 26, 2021. And then there's the Ontario Critical Minerals Framework discussion paper, and you can comment on that. And that has a number of 019-3281. And you can comment on that until May 9th, 2021. And some of these may or may not have and if you want to mail them, you can mail the Ministry of Energy and Northern Development and Mines and Mineral Division, Strategic Services Branch, 2nd floor, 933 Ramsey Lake Road, Sudbury, Ontario, P3E 6B5. And that's for the Ontario Critical Minerals Framework discussion paper. And this is for some. I'm just going to change. And yeah, so, and then there's a phone number listed there. But I gave you the lotto. And I plan on doing that for future episodes. Giving the like at least the mailing address, especially for some of the more controversial ones. And then there's also like the Greenbelt one. I think the Greenbelt one, they're trying to say that they protect the environment here, look at us, but in reality, it's a smokescreen. And those areas of that require protection throughout Ontario. Ontario is a huge province. You can't just focus on the Greenbelt. And because we don't have a lot of wetlands and forests throughout Ontario, and we should protect areas province-wide. And areas are significant for a reason. And I said before that the environment should be protected. They should have standing in court. And then, yeah, my final thoughts is I have a couple minutes left, so there was a product, disposable product, that has seeds in them. There's a growing number of products like this. But seeds are not necessarily from North America. They could be invasive species locally. And there's a risk that if people use the product as intended to go into the garden, they will end up spreading invasive species globally. And this will also impact biodiversity and cause a lot of environmental loss. So anyways, that is what I had planned for today. And I hope that you enjoy the rest of your week. And I will have a new show either this week or next week. Well, have a good one for now. Bye.